I have the privilege of co-presenting today with Willie Handler. No one in Ontario knows more about the evolution of auto insurance in Ontario and where it may go than Mr. Handler. He's been working for decades with the government and is now in private consulting for the insurance industry and the government and anyone else for that matter, presumably. And he knows what may be on the horizon and where we've been. He was the lead policy advisor for the government for many of the iterations of late. So I'll be presenting with Willie Handler. We're going to cover 4 topics. The first one is an update on where we are at with the catastrophic impairment designation. The second one is the mandated Fiscal licenses, which many of you should be very familiar with as the first deadline has passed. The third one is a new, revised, further defined definition of incurred, which is causing some problems. And the last one is Bill 15, which has received first reading with changes to the dispute resolution process for Fiscal and some interest changes that affect the lawsuit side, the tort side. I've written a paper, which is at tab 4, which summarizes what I'll be addressing. And this is a question and answer segment, but rather than have audio questions where we're not sure where they're going to go, we are going to let people text me throughout the conversation, and I'll do my best to relay those questions that are relevant. And I will be starting off the questions of Mr. Handler, so we have a handle on where we're going. First off, catastrophic impairment definition. I think this is the 4th year I've spoken about the catastrophic impairment designation. And every time I've said the changes are imminent, and I've been wrong, thankfully, every time. So this year we have the privilege of Mr. Handler's insight, so he can make the predictions. He's in a much better position to make those predictions. In terms of a background, the government commissioned an expert panel who's had recommendations regarding an overhaul of the very important catastrophic impairment definition, which affects accident benefit rights following a motor vehicle accident by roughly $2 million. It's a huge factor. And the definitions that have been proposed, in my view, narrow the definition. And I'm going to ask Willie to weigh in on that as the first question. Are the proposed definitions a narrowing of the catastrophic impairment definition?
That's good, right? I would say that some of it is, and some of it is not. Some of it's just a clarification or an update of standards that were developed in some cases decades ago, before I even started auto insurance.
So just to give everyone an understanding of what the changes are, and they're just proposed, and there's nothing that's happened in the last year or so. But some of the proposals included the elimination of the Glasgow-Coma scale test as a means to achieve a catastrophic impairment designation. And if that does go through, would you agree with me, Willie, that it would completely narrow the field of people who would qualify for a catastrophic impairment designation?
I would have to say that in the scheme of things, probably it does. But again, the current measure, the Glasgow-Coma scale, is a very rough measure and was never intended to be used as it's been used or as long as it's been used.
Okay. So some of the other changes involve the elimination of the merger of the whole person impairment test between the psychological and the physical. So preventing that from happening, even though the courts have said it would be unfair to do that. And if that change is passed, then it would also reduce the number of people who would qualify, right?
There's no question that would be the case. However, in my opinion, though you haven't asked me yet,
sure,
that's probably the one change that's least likely to make it through. And likely part of the reason is not just because of opposition to it, but there may be constitutional issues as well.
Okay. So after all the expert reports came out and the draft legislation was proposed, or the draft wording, there was a lot of concerns raised. And the concerns raised were with the elimination of the GCS and the unfairness from a constitutional basis of eliminating the merger of the psychological from the physical and the whole person impairment test, for one. So I think the big question for you, Willie, is where are we going? There's a lot of people in the room whose industries, their practices, their businesses will be affected by a narrowing of the definition. So can you give us any insight in what you might expect to happen with the catastrophic impairment definition in the coming years?
As far as timing goes, I wouldn't say any change is imminent. Obviously, the government has struggled with this issue for several years now. I wouldn't say that they're any closer to a resolution than they were 2-3 years ago. There may be some momentum to make change because of their rate reduction strategy, though this is not a big cost saving for the government as well. So that's not really what would push it. I'd say the Glasgow-Coma scale is most likely to disappear. As I mentioned before, it was never intended to be used as it was. It was intended to be an interim measure when it was introduced, I believe, 1993, 94. Actually, only to evaluate the level of attendant care, and then later got incorporated into a catastrophic impairment definition. And that the government had always committed to finding a different measure to be used down the road. I'd say that the elimination of combining will not happen, but what will likely happen is the government will have to probably come up with a process, probably enshrined in the regulation, on how to combine, because right now it's being left really to a certain extent up to arbitrators in the courts, and that's not a very good way to predict whether or not someone is catastrophic or not.
And then the last question I'd like to ask you on the catastrophic issue is what do you anticipate will happen with the upcoming 3-year review, which is set to be released any month or day now?
I would say that that catastrophic impairment will be mentioned in the 3-year review. But considering that the review is being done by the superintendent, who originally submitted the report to the government on changes to catastrophic impairment, it will likely say, go ahead and make the changes that I recommended 3 years ago.
Okay, we're going to move on then to the second topic, which should be highly relevant to the people who are here today. The mandatory fiscal licensing. This is a new mandatory license for all those who bill insurers for accident-related work through HCI, which is the website, the health claims for auto insurance process, where you submit your invoices directly to the insurers and get direct payment. Makes it easy. You don't have to deal with the claimants directly and deal with collection issues. And now they've mandated licenses effective December 1st, 2014. There's plenty of information at tab 4A. I've included the majority of relevant information from the Fiscal website, the frequently asked questions. So for those who aren't familiar with it, why it's required and how it's being implemented, you can check that out. So Willie, can you talk to us then about the reasons for the licensing?
The reason for licensing, the origin is with the Auto Insurance Anti-Fraud Task Force that made that recommendation. The intention was that to provide some type of regulatory oversight to facilities who aren't directly regulated, and to provide some transparency around their operations, because there were, at the time, a number of fraudulent operators operating in the GTA. And there was no way to sort of penetrate that corporate veil that existed without some type of regulatory oversight.
Okay, and do you think it will succeed then in its stated goal of combating fraud?
Certainly, the application process and the information being requested will likely accomplish that, and I expect it will have some impact on what remains of fraudulent operators in the area.
Okay, so dealing with the fees for the licensing, there's at page 20 of 4A is the information from the government about the fees that are expected, and the fees are $337 for everyone who wants a license for every facility, plus $15 per claimant. So per accident benefit file, unique accident benefit file you're involved in, $15 per file goes straight to the fiscal licensing fee, and plus $128 for every location that you operate. So in terms of those fees, do you expect any changes in those fees over time, noting that the $337 fee is a one-time fee when the others are annuals?
I would expect there will be some type of evolution with respect to the fees. They were designed to cover the cost of operating this oversight, this regulatory system. But the cost may change, will likely change, based on the number of facilities that ultimately apply for licensing, the amount of investigation that needs to be done, the level of complaints that come through. So, in fact, costs could go up, but they could also go down depending on how this process evolves.
Do we know if anyone's, this is a question from getting text right now, do we know if anyone's been denied any applications for licensing at this point?
I don't think any, but I'm not aware that that they've actually begun to issue any licenses yet, unless there's somebody in the room that has one. And in fact, I'm not quite sure. I think the numbers are below what is expected. There was a deadline of August 31st, in which would guarantee a license be issued by December 1st, which is the date in which the licensing system comes into effect. But there are providers who I've spoken to who are opting out, which is you do have the ability to do that. In which case you can't use HCI, and you would have to bill your patients directly, and they would get reimbursed by insurers. So that works for small providers who don't do a lot of auto insurance work, but probably not anybody in this room.
By a show of hands, how many people in the room intend to seek their license but have yet to do so? Okay, so you should get on that, because as Willie mentioned, there was an August 31st deadline by which you had to apply to ensure your license would be addressed before the December 1st implementation date. Okay, so other questions about the licensing. I know it's very specific. They're welcome to come up to Willie at the break, and he'll be glad to answer those questions. This is more of a topic that I'm going to address, which is the new revised definition of incurred. When the September 1st, 2010 changes were announced, they switched the definition of incurred to make it so that the provider of care or housekeeping assistance had to prove some degree of economic loss in order to qualify for the payments associated with either that care or housekeeping assistance. Now, us plaintiffs' lawyers manipulated that definition to some extent to say, well, it's some degree, it's any degree. So if you miss one shift of overtime, then you qualify for, could be up to $6,000 a month in attendant care. Now, manipulated within keeping of the legislation. And a court confirmed that that was the correct interpretation of the legislation as it was written. So we were doing nothing wrong. But the government unilaterally made a change to that legislation in February of 2014. And I say unilaterally because it was done without any consultation. And the change now requires a dollar for dollar loss. So you must prove a specific economic loss and the degree of that economic loss to qualify for payment to that same extent. In other words, only somebody who forgoes $6,000 a month in pay will qualify for that $6,000 a month in attendant care. So what we've been doing in response is we've been outsourcing. I can no longer ask the spouse, the retired parent, whoever else to do the work because I can't get them paid for it, generally speaking. So we've been outsourcing. And outsourcing is expensive. And it doesn't cover the 24-hour supervision that's often required, leaving the family doing a good portion of the attendant care without being paid by the accident benefit insurer. Now, the answer from our perspective as a plaintiff's lawyer is we shift it to the tort side, the lawsuits which we often can bring against at-fault drivers. And it makes those lawsuits bigger because now the family is uncompensated for the care and deserves to be compensated. They're pressing their limits to make it all happen. So the question I have for Mr. Handler is, in light of that change and the new approach, which is outsourcing, what do you expect the insurers to lobby to do in response?
I think they'll have to pay, and this was a poorly thought out change that the insurance industry suggested the government would save them some money, but it's not going to. But that's sometimes what occurs within the insurance industry. They lobby the government for changes that have zero impact. In some cases, can even have a negative impact on them.
Okay. And is this pattern of non-consultation with now a majority government, is that a fear? Is that a reality where they're going to start just announcing changes and feel no need to consult with the community?
No, I don't think necessarily that's the case. There have been instances over the years where the government has made a change without doing any consultation or minimal consultation, but that's rare. And I think going forward, there really is a overriding requirement within government to do adequate consultation before doing regulation change, and I think that will continue.
And I'm getting a lot of questions about the fees, back to the licensing issue. And the questions that are coming through are, will the fees charged by the providers remain the same, or can they now be increased to offset that $15 per unique benefit case?
Well, my understanding is that the superintendent hasn't increased fees, the fee schedule for the last 2 years now. I don't anticipate that there will be a change to reflect that. So, I mean, that's a reality that's out there right now.
So the last topic we're going to cover today, and we'll try to get back to some questions, time permitting, is this Bill 15. Bill 15 is a revamp of the Fiscal, the Financial Services Commission of Ontario. It's being eliminated, in accordance with this legislation, if it's passed and when it's passed, for the License Appeal Tribunal. So no more will complaints about the manner in which treatment assessment plans are responded to or catastrophic designations be dealt with by Fiscal. It would be dealt with the License Appeal Tribunal. And no logistics of how that'll be implemented have been announced, and a further regulation will be required. And this looks like it's going to be a reality because we have a majority government. The bill has already received first reading. But one thing they've taken away is the court option. Right now, we get to mediate our disputes with Fiscal, and once they don't resolve, we have the option of arbitrating through Fiscal or going to the courts. And we like that option. It helps us keep the insurers honest in if and when they act inappropriately or reprehensibly on occasion. That option is completely eliminated by this proposed legislation, and that's a big cause for concern for plaintiffs' lawyers. It should be a cause of concern for accident victims as well. And the other change that's buried in this bill is a reduction in the prejudgment interest rate available in tort claims for general damages. So remember, on this side of the equation, when you're suing the at-fault parties, you can claim damages for pain and suffering. And you're entitled to interest at a mandated 5% per year rate, a favorable rate in comparison to current interest rates. And because of that 5% favorable rate, insurers would often want to resolve simpler cases where primarily one of pain and suffering as opposed to future income loss or future care. They'd want to resolve those fairly quickly. It was in their best interest. They were having a hard time making 5% or more. They might as well pay it out. The change would make it the mandated Courts of Justice Act rate, which is currently 1.3% per year, which means that the insurers are better off holding their money than paying it off to the claimants, because in most cases they can make more than that. So Willie, what's your view on the issue of the interest rate change and how it may affect the insurer's response to those tort claims? Would you agree with me it's going to disincentivize them from resolving these cases early?
I think in isolation, certainly it's going, it would have an impact, but I think it's already. I think it already exists because of the the length of time of cases and so on and so forth. That I don't see it taking any slower than it is. But certainly there. I mean, everybody knows how long it takes to get a court date nowadays. It takes forever. So, there isn't necessarily a push to to make a settlement until you get closer to a court date anyway. So, it's a complicated issue. It has to do with whether the parties are ready to settle and so on and so forth. This is just another factor in there, and it may have a negative impact. How much of a negative impact? It's hard to say.
And in terms of the License Appeal Tribunal, do you expect that would improve the process from an accident victim's perspective?
Well, I have a bias because I work with Justice Cunningham on his report, and I believe that the recommendations that were made by Justice Cunningham will make the system quicker and less costly and better for the users. But the issue now remains is whether or not the government will be able to implement it, the vision that Justice Cunningham had. That's really the critical point. But right now, the system, I don't believe it's functioning as it should have, and certainly not the way it was originally set up. It has really gone off the rails to a certain extent.
So we're just going to wind up because we are out of time. I know I've received a lot of questions, and I've tried my best to relay as many of them as I can. In conclusion, though, the cost of doing business for healthcare providers has gone up with these licensing fees. It's not a huge amount, but the $15 fee will dissuade people from getting involved in cases where they're only asked to do one treatment and assessment plan, for example. It cuts the margins. Families can no longer get paid immediately for attendant care in most situations, and we're forced to outsource care and housekeeping benefits in many situations. And when it comes to the catastrophic definition, we don't know what's going to happen. Willie's made some predictions about the elimination of the GCS, or at least the probable one. And with the dispute resolution process, who knows if it's going to be an improvement from an accident victim's perspective. We know from our perspective the fiscal process does not work. It does not work. It is slow. It is impossible. It is expensive. It is not suited for the urgent needs of our patients, clients. And the reality is that lobbying to a majority government is challenging, but we can't stop doing it. There will be an election at some point, and we need to make sure that the politicians understand that this is a big community with a lot of support, and these are important causes. So thank you, and thank you, Mr. Handler, for all your hard work.